myself first. I said I grew up in a small town. My father was a family practitioner who delivered about 3,000 babies during the time that he practiced. He was also the medical director of the 2 nursing homes in Roanoke, Alabama. So he was gone quite a bit, either delivering babies or over at one of the nursing homes. My mother, who is still alive, was a nurse, and she was the head nurse at one of the nursing homes in Roanoke for about 10 years. So I literally grew up around medical care, going into hospitals, going into nursing homes, and that sort of thing as a young person. My mom is in a nursing home right now and has tested positive for COVID at least 3 times, but has never gotten sick, fortunately. She is 95 years old, on oxygen and bedridden. So, you cannot tell who is going to get sick when they get tested positively for the COVID, which is, I guess, fortunate in that not everybody who you might expect gets sick. We've had a number of people here in our office who have gotten sick. We've had one individual that got sick back in October and still has not been able to return to work because of the residual effects that she is still experiencing. I had a life before I became a lawyer. I've been a lawyer for soon 40 years, but I did some other things before I went to law school. So I know a little bit about what it's like to talk to a lawyer and get a question and to scratch your head. And because of that, I collect lawyer jokes. It's difficult sometimes to find a lawyer joke that also involves a physician. But one of my favorite jokes involves an accountant, an attorney, and a physician. And an elder individual who discovered that he had a terminal illness. And he said, well, I'm going to bring my lawyer and my physician and my accountant all together and talk to them and ask them to do something, which he did. And he met with them together and said, I'm going to give each of you $200,000 to do with what you will, but I would like for you, when I die, to give me back that $200,000. So all of the accountant, the attorney, and the physician agreed to this, and they took the money. And the individual lived a little bit longer than everyone expected, but he did die. So they had the funeral, and during the funeral, each of those individuals came up and put an envelope in the casket of the gentleman who had died. And he was buried, and afterward, the 3 were talking. And the accountant said, well, I was really pleased to get that $200,000. And initially, I thought that I could invest that money, make some money, and give him the $200,000 and have some left over. Unfortunately, our computer system busted, went down, and I had to invest most of that $200,000 in replacing our computer system. So it was basically a loan to me, which I was able to repay, and I put that money in the envelope back in Mr. Smith's coffin. And they looked at the doctor, and the doctor said, well, something similar happened to me. The COVID pandemic happened, and Chris and I have talked to a number of physicians, particularly in the last few weeks, whose practices have suffered substantially because of the pandemic. Everybody, the lay people think all the physicians are busy and making money because of the pandemic. That's not necessarily the case by any stretch. So he said I had to use that money to keep my practice open. Fortunately, I was able to get one of the PPP loans, and I used that money to replace the money, and I put it in his coffin in that envelope. And so the accountant and the physician turned and looked at the lawyer, and he kind of smiled and looked, and he says, it was really hard for me, but when I wrote that check that I put into the coffin, I repaid him the $200,000. So lawyers and accountants and physicians see the world differently, obviously, and what we do and what we say. So we recognize that. What we want to talk to you today is about the legal responsibilities for suspected, and that's an important word in this presentation, is suspected elder abuse, not known elder abuse, but suspected elder abuse. And we're going to go through the slides here. And the first slide involves about why you should think about and why you should make reports when you have someone 65 years of age or older who you believe may have been subject to some kind of abuse by someone. First of all, obviously, it's the right thing to do for everyone. We want to protect the older people who may be, because of various reasons, may be sick, otherwise are unable to do everything they normally might be able to protect themselves and to protect their investments and finances. Second of all, there are potential fines and penalties for failing to report. Chris is going to talk about the next one, and that's a federal law, where there's potential $300,000 liability potential there for failure to report. There's potential exclusion from federal health care programs under the Elder Justice Act, again, which Chris is going to talk to. Again, we've represented physicians and others. If that happens, that is in effect the death of the practice when you cannot bill Medicare or Medicaid. Then under Alabama law, there's some potential criminal liability and a misdemeanor and up to a $500 fine for failure to report. The Adult Protective Services Act of '96 was initially passed, and it has been amended over the years basically as one, more people as a percentage of our population are over age 65, and as more things come to light, unfortunately, things that are done to or for elderly people or not done to or for elderly people. So basically there has been an expansion of what is included as far as potential aggravation about these elderly folks. So if we talk about abuse, neglect, exploitation, and degrading treatment in these laws. The other purpose of these laws is to help and protect the individuals and give them as much personal liberty and exercise of their rights as is possible, considering whatever situation they may find themselves in. Again, my mother in a nursing home, bedbound, on oxygen. She obviously cannot do physically what she normally would be able to do, but the intent is to give her as much freedom as is possible considering her physical situation. Again, the Act. Here's the basic structure. The services are to protect against danger to the health and safety of individuals. That's why it's there. There are emergency protective services. Now, when the law talks about emergency protective services, and when you talk about emergency protective services, I said we're different. When you talk about emergency protective services, you're doing an evaluation and taking immediate action. The law vision of emergency protection services doesn't act quite as quickly, unfortunately. There has to be an investigation. There may have to be a court proceeding and an order by a judge saying this individual is in some danger and a protective order issued by the court, which obviously takes some time as opposed to the normal way you would make a determination of there being an emergency situation and doing something about it. Again, protected placement and other services. Lots of times there has to be or most of the time, there would be an investigation by the Department of Human Resources, DHR, and some evidence shown to DHR that something is going on that indicates some abuse, neglect, exploitation, sexual abuse, or emotional abuse. So DHR may petition a court to issue an order. It's not only DHR that may make a petition. Other interested persons could also do something similar. For instance, relatives of the individual involved in the situation. There is mandatory reporting under the law. The law says that physicians and other practitioners of the healing arts are to provide a report when they have reasonable belief, to believe something is going on we'll talk about in a minute exactly what's covered, but when there is a reasonable belief for one of these factors is affecting an individual that you are providing care to. There are some good parts to the law. The law provides legal immunity for making these reports. Basically, when it says legal immunity, it applies to both civil actions, being sued, and a demand for money being made, and criminal accusations also are covered by this immunity. Unfortunately, along with immunity, there are some penalties for failure to report when there is reasonable cause to believe something is going on with an individual. The law provides specific definitions for each of these terms, as the law will do. I believe, personally, these are broad enough to cover most situations that I'm aware of that medical providers could encounter with someone. Abuse, physical pain or injury, deprivation of services, things necessary to maintain the mental and physical health of an individual is abuse. So it doesn't have to be only pain, but other sorts of things necessary for a good and reasonable life for someone to have. Emotional abuse. This is relatively new from the law. The initial law talked about abuse, physical kinds of abuse, and emotional abuse was later on added to the law. And this is willful or reckless infliction of emotional or mental anguish. What willful and reckless means is you have knowledge. You know that if you do something or don't do something, something bad is going to happen to that individual. It's not neglect. It's knowing and doing something anyway. It also includes physical or chemical restraints for medication or isolation or punishment as a substitute for treatment or care. So it also could include, conceivably, forms or former forms of medical care in its definition. But really what it's talking about is the reckless and willful infliction of emotion and causing emotional and mental problems as a result of that. Sexual abuse. It's pretty clear. The law under Section 13A 660 mentioned there, that's the criminal law. The criminal law has had in it for many years that it is, again, against the law to rape, sodomize, sexually touch someone or other sorts of things. So sexual abuse would include any of those current definitions under the criminal law. So if in fact there were sexual abuse going on, someone could be accused of civil sexual abuse and criminal sexual abuse. Neglect. It is a failure. Now this is different from that reckless and intentional act that I was talking about earlier. It's failure to provide food, shelter, clothing, medical services, health care, who are unable to care for themselves. And failure to provide these needs for themselves when the individual who we're talking about is unable to do it. So, the individual at home who is not being fed, the individual at home who is not being provided the medications that have been prescribed to them, the individual at home whose bedclothes aren't being changed on a regular basis, that sort of thing is what the intent of the law was and is, but it obviously can cover broader kinds of situations than just someone being at home and a family caregiver failing to do something, although that is many times the situation we're talking about. Exploitation. Again, this is a rather new part of the law. Recognition in it, honestly, has been a gradual recognition that elderly people can be taken advantage of and their assets be wasted, is the term used in the law, that is, expended without their consent or even knowledge. And unfortunately, this seems to happen in some cases, at least fairly regularly. But the individual, their Social Security check that comes in monthly. Some individual is taking that check, cashing it, and using it for their own purposes, as opposed to for the purposes of taking care of that individual. There's another part of this definition, if you read down there, talks about care of an unlicensed hospital. This was a situation that was added to the law about 12 years ago. And what was going on there was people were being treated particularly in a hospital, and they were ready to go home or ready to go somewhere, and needed transfer. And they were being transferred to unlicensed assisted living facilities. Unfortunately, at the time, there were a fair number of unlicensed assisted living facilities. So this was added to say that hospitals and other healthcare facilities that are transferring a patient to another facility need to check the license of that facility. And that is something that is now available for those individuals to do and to check online to see whether or not a facility is actually licensed. This really hasn't been a problem in more urban areas, but particularly in rural areas. This has been a problem where there just really aren't many available resources to use, and unfortunately people were being referred to unlicensed facilities. I don't think that is much of a problem as it was back in 12 years ago when this was added. A misappropriation of property of a nursing home resident. This applies particularly to individuals who are in a nursing home. Belongings, money, or otherwise in a nursing home would apply to this thing. Again, using my mother as an example. I have not been to see my mother, unfortunately, since March. But one of the things I would do is she loved chocolate, and I would take her a box of chocolate. And she would say, "Greg, put the box of chocolate in the drawer there." There are other residents who also love chocolate, and if they see the box there, they will come by and help themselves to some of my chocolate. That's not what we're talking about. As one resident, we're talking mostly about someone who works at the nursing home, coming in and taking or withholding something from an individual. Again, back to mandatory reporting. Who has to report? Physicians, other practitioners of the healing art, any caregiver is supposed to make a report under this law. And that would include healthcare facilities are supposed to report as well. what is covered when there is reasonable cause to believe that a person has been subjected to abuse, exploitation, sexual abuse, or emotional abuse. The reasonable cause is important here. You do not have to know for certain that something is occurring, but you do have some reasonable reason to believe that something inappropriate is occurring with that individual. Then an obligation to report comes about. Who do you make a report to? One would be the County Department of Human Resources. Second choice would be the Chief of Police if you're within a city, or a sheriff if you're in a county and not in a city. Public health. There are mandatory reporting, particularly within nursing homes, if one of these occur. What is required when you make a report? First of all, an oral report. That is a telephone call. That's supposed to be made immediately. Once a determination is made that I have reasonable cause to believe that someone is being abused, exploited, or otherwise, then I have an obligation to check. Now, a determination of reasonable cause may involve sometimes some investigation about what's going on. This whole process, by the way, can be extremely frustrating for providers. One time, I remember I made a similar report for a child at a hospital. And it was a young child came in, and she was about 4 years old, and there was genuine concern at the hospital by the physicians and by the nurses that this child was being physically abused at home. And I had conversations with some of the nurses and some of the physicians as to the reasons they felt like. And there was genuine reason to believe this little girl who had been brought to the hospital emergency room was being abused. The hospital could really only hold her for treatment for a limited period of time before she was well enough to leave. And I made a report on behalf of the hospital, on behalf of the physicians, and behalf of the nurses to the Department of Human Resources. We had very, very good evidence to have this belief that this little girl, who was a beautiful little girl, and some of y'all may remember John Benet Ramsey, the little blonde-headed girl who was abused and died apparently as a result of some of that abuse. This little girl kind of reminded me of her. Anyway, we made a report to the Department of Human Resources, and they started their investigation. The hospital had to release the little girl to go home before the Department of Human Resources could complete their investigation. And that was very frustrating. It was frustrating for me personally because I had seen the little girl. I had had the conversations with the physicians and the nurses and to make that decision that she had to be released. Later on, she was removed from the home. But again, what is an emergency situation for a physician or a nurse is not necessarily what is an emergency for the wheels of justice. Sometimes the wheels of justice move inordinately slow. At some point, a written report needs to be made to whomever the oral report has been made. There's no specific timeline in the law that says when that written report has to be made, but it should be made. And it's deemed to be satisfied, particularly in a nursing home, if you follow the Board of Health rules as to. DHR, again, is supposed to, within 7 days, following an oral report, to conduct an investigation. Unfortunately, again, there is no penalty otherwise if they don't meet that 7-day requirement. So they don't always meet that 7-day requirement, but they are supposed to, as closely as they can, make that investigation and complete that investigation within 7 days. They are supposed to make a written report of their investigation of what they have found in this individual, whether it's a child like the situation I was describing to you earlier, or whether or not it's an older person who we're talking about today. And they have parts of what they're supposed to include in their report. Chris and I suggest that when you make your written report, this would be kind of the minimal part that you ought to include in your written report. Obviously, you need to give the name, age, and address of the individual you're reporting about, so the department can figure out how to get in touch with them, to perhaps to interview them if that's necessary, and make a determination of whoever the other persons involved with the person who may be being abused, exploited, or otherwise may be involved with. Describe the nature and extent of the injury. If there's physical evidence of abuse, describe what that would be. You know, if there are bruises or otherwise, if it's some kind of exploitation, some evidence to show that what that person otherwise might be entitled to, they're not getting. Other facts or circumstances that would help DHR in their investigation would be very helpful. Again, this is what DHR has to report, but it will help them in making their report if you can give them as much of this information in your report to them. They will be able to do it quicker and more thoroughly. Immunity. Immunity is very important in any kind of reporting law like this. There is immunity provided. I said there is both criminal liability immunity and civil liability immunity, meaning if you were sued for reporting, you could take this law and your lawyer could say, look, we are given immunity under this law for making this report, and this lawsuit cannot proceed any further. Criminal liability, the same idea. Some overactive law enforcement officer decides there ought to be some criminal liability imposed. There is protection, immunity. I guess since we're all familiar with the vaccination process going on, you have immunity, hopefully, from the COVID once you get the vaccination. This is the same idea. Immunity from potential civil actions demanding money or criminal actions demanding money or something stronger. The immunity is for making or participating in the making of a report. And furthermore, it includes if you participated in any kind of judicial proceeding. So if you're called after you make a report and ask questions by the Department of Human Resources as to what you know, that would be included. If you are asked to testify in the hearing before a judge, when the judge is asked to make a decision whether or not a protective order should be imposed, you would be protected for testifying in such a proceeding. And again, the intent is to enable people to participate without fear of some kind of retribution for making a report like we're talking about. There's also, I mentioned earlier, there's a criminal law for some of this. So an individual who is found to have violated one of these other provisions we talked about could also be found for violating the criminal law and could be sent to jail for some of these acts or many of these acts. You'll see at the bottom here, exempt from the definition of abuse and neglect any acts that constitute the practice of medicine. This was a section that got added to the law when this was amended by your association, the Medical Association of the state of Alabama. Rightly so, was concerned that when a physician or nurse is providing treatment to an individual, somehow they could be accused of abusing or neglecting that individual because of the treatment they're providing. Well, it's clear you can't be accused criminally for providing treatment of one of your patients under this particular criminal law. I saw this week in an additional protection for physicians, and particularly when an examination is being made of a male or female patient where the genitalia or otherwise involved, chaperones are going to be involved and recommended. Actually, the way I read the regulations, mandatory. And it's the same idea, to give protections to physicians later on if there's some kind of accusation of some violation of that individual. With that, I'm going to turn it over to Chris. Megan, were there any questions at this point?
Yes, we do have one question from Dr. Stewart, who says, to whom or what entity are we to report? I've always reported to DHR, but I've never seen anything happen.
You have experienced my frustration, Doc. You can report there either to law enforcement, which would be the county sheriff, or if you're in a city, the police department, or to DHR. So, and there's nothing saying you can't report to both DHR and to law enforcement. But I can tell you, as I said in my earlier situation with that young child, the frustration that can be experienced with reports to DHR. The law moves slowly sometimes, and they have an investigation they're supposed to do within 7 days. I dare say, I would bet money on it, that DHR is moving even slower than normal because of COVID and the restrictions that are placed on individuals in face-to-face encounters. So there's nothing preventing you from making a report to both DHR and either to the sheriff, if you're not within the city limits of somewhere, or to the police department.
Megan, any other questions for right now?
Not for right now.
Thank you. Chris and I are trying to observe the mask ordinance, so we will.
Not sure how technically correct we are,
But we're trying.
doing what we can.
It's appreciated.
So Greg just covered the state law, Alabama specific state law side of things. I don't have as many good jokes or really any good jokes or stories to tell like Greg does, but I'm going to try to cover the federal reporting side of things real quick, and also go through a couple of examples, and then we'll see if there's any other questions at the end. So like I said, Greg covered the state side of things under a couple of different Alabama laws, but as a result of the Affordable Care Act passed back in 2010, there's also a federal reporting requirement related to long-term care facilities. This was created by Section 2046 of the Affordable Care Act, and I think it's now codified at Section 1150B of the Social Security Act, which might make it easier to find than that. At any rate, this section that was added in the Affordable Care Act applies to long-term care facilities that receive federal funding greater than $10,000 every year. And if that facility participates in Medicare or Medicaid, that's a pretty low threshold to hit. It may be a little bit different for an assisted living facility or a specialty care assisted living facility that does not primarily accept Medicare and Medicaid for its payer sources. But certainly a nursing home that's Medicare and Medicaid enrolled would very easily hit that threshold. The owner or operator, or in our case, the administrator of the nursing home, has got to make a determination every year of whether or not it receives $10,000 or more in federal funds. And once that determination is made that the long-term care facility qualifies under that Elder Justice Act, the owner or operator must notify all of the covered individuals, and we'll discuss in a second what that means, all the covered individuals of their reporting obligations under the Act. A covered individual is a pretty broad definition. It includes not only the owner or operator of a long-term care facility, but also employees, managers, officers, and most importantly, agents or contractors of a long-term care facility. I imagine as medical directors, a good number of you, if you do work as a medical director in a nursing home, an ALF, a SCALP, or another long-term care type facility, that it is done under a contract as an independent contractor with that facility. That may not be the case all the time. Some of you may be employed directly at a facility, but at any rate, the Elder Justice Act covers both employees and contractors as covered individuals who would have a reporting requirement under specific circumstances described in the Act. The Act also requires the facility, long-term care facility, to post a notice conspicuously in the facility that informs employees of their rights. We'll get to this in just a minute, but there are a number of anti-retaliation provisions that protect employees who report instances that are required to be reported under the Elder Justice Act. And because we want to, or at least under the federal law, we want to encourage people to report these instances of abuse or potential crimes committed against an elder individual in a long-term care facility. We want the people that are subject to this reporting requirement to feel comfortable that they're not going to be subject to adverse action from their employer or from the long-term care facility in exchange for them reporting a potential crime committed against a resident of the facility. So there is a stern requirement to have those notices posted around the facility so that employees, staff, contractors, everyone is aware of their rights to report potential crimes against facility residents, and that they're comfortable in their right to do that. So a little bit of the basic structure of what is required to be reported, who it's to be reported to, and that kind of thing about the Act. We already covered what a covered individual is. Again, that's owners, operators, employees, and even independent contractors of a long-term care facility. And those individuals, as covered individuals, are required to report, again, just like what Greg said about Alabama law, when they have a reasonable suspicion. They don't have to be absolutely certain. They shouldn't report it if they just have a hunch, but don't really have a reasonable basis on which to confirm their belief. But if they have a reasonable suspicion that a crime has been committed against a resident, this is a little more narrow, I would say, than what Greg was talking about under the state law. Greg covered abuse, emotional abuse, neglect, exploitation, any of a number of things that likely could be a crime if prosecuted, but in this case, we are talking specifically about a potential crime as defined by various statutory requirements in state or federal law against a nursing home or a resident of a long-term care facility, not just nursing homes. So if you have a reasonable suspicion that a crime has been committed against a resident of a facility where you are an employee or a contractor, you're required to report that. And who do you report it to? It's supposed to be reported to the Secretary of HHS. for one, and also to a local law enforcement officer of the political subdivision where this facility is located. So that could be, a municipality, a county. I guess if you're doing services in Louisiana, it could be the local parish. So you are required to report both to HHS and to law enforcement when you have that reasonable suspicion that a crime has been committed against a resident. And there are two different reporting timelines for when you have to make this report. In the event that there is serious bodily injury that results to the resident, the report has got to be made at least, within 2 hours after the time you develop your reasonable suspicion. I'm not sure who's going to be watching their stopwatch to determine whether you made it within 2 hours or not, but I think that the key requirement is that if you have a reasonable basis that a crime's been reported or committed against a resident of a long-term care facility, and that's going to cause serious bodily injury to the resident, that needs to be reported practically immediately. And in any event, we've got to make efforts to have that reported within 2 hours. If there is not the involvement of serious bodily injury, a little bit more relaxed requirement, but within 24 hours after the time you form that reasonable suspicion. I mentioned earlier that there are anti-retaliation protections for those that are reporting potential or suspected crimes against residents of long-term care facilities. The long-term care facility itself cannot discharge, demote, suspend, and I won't run through the entire list, but basically take adverse action against the employee for filing a report or making a report under the Elder Justice Act. In addition, they cannot file a complaint in the event that this employee is a nurse or another licensed employee. The facility can't file a complaint against that employee's license with the appropriate professional regulatory board just for the employee filing a complaint. You'll notice here that I've got the word employee highlighted just about every time it's on the screen. And I think that's an important distinction for you in many cases as medical directors, because again, I imagine a lot of you are working as independent contractors for these facilities and would not be employees. So this is a very important distinction in the Elder Justice Act, that there are a lot of people that are required to file these reports, including independent contractors, but the anti-retaliation protections only apply to a bona fide employee of the long-term care facility. So if you're an independent contractor and have a medical director agreement with a facility, you may have an obligation to report a suspected crime against a resident, but you do not have protection against the facility terminating your contract. In fact, the facility may or may not have provisions in the contract to terminate at will or for certain other grounds for cause, but even if those grounds existed in the contract, again, that's in many cases probably an independent contractor arrangement and would not be covered by the anti-retaliation protections in the Elder Justice Act. There are certain penalties associated with the Elder Justice Act that Greg mentioned earlier. These are probably the more severe of the penalties. I think under state law, under the Adult Protective Services Act, it was somewhere in the hundreds of dollars and potential 6 months or so in jail. Under the Elder Justice Act, we're looking at baseline fines of $200,000 or $300,000 if violation increases harm to the victim or the crime results in harm to another individual. These penalties are going to likely be imposed against the facility itself, but also could have penalties against an individual for failure to report. In addition to the almost excessive penalties involved there, because that's a pretty significant sum for failing to file a report, there is also the authority for the HHS Secretary to exclude from Medicare and Medicaid participation and other federal health care programs an individual who fails to file a required report under the Elder Justice Act. The good news is, on the other side of things, there are also penalties against long-term care facility for retaliating against employees. Again, you're looking at potential civil fines up to $200,000 And that facility can also be excluded from Medicare and Medicaid participation for up to 2 years if they retaliate against an employee for failing to report, for reporting under the Act as they're required to do. That covers the federal reporting requirements. We're going to run through a few examples. You'll have to excuse me. I apologize for these being probably a bit exaggerated, a little bit contrived, but we want to make the point and go through some of the analysis about whether this constitutes abuse, neglect, exploitation, etc. under Alabama or federal law, and what sort of reporting might be involved. So let's say that you are a medical director at a nursing facility, and you notice a nurse or another employee taking, let's say, jewelry or Greg's mom's chocolate out of her bedside stand, or maybe some other personal items, again, from the bedside table. If we're taking chocolate, probably not going to be any sort of exploitation, but any items of significant value, whether financially or otherwise, to that resident, if those are taken by an employee of the nursing facility or anyone else, for that matter, that could potentially constitute misappropriation of the resident's property. It could potentially constitute exploitation, depending on who is taking that property. Just a couple of things where that conduct might fit under a reporting requirement, at least under Alabama law. On the federal law side of things, if the property that's being taken is taken, I guess if it would be a crime, again, to take that property, depending on what the intent behind the taking of the property, whether it was for protection, perhaps, and that property would be returned to the resident later. Maybe that's not a reporting obligation in that event. So a lot of these determinations are very nuanced in whether or not there is a reporting requirement there.
Example, I talked to my mom. I am able to talk to her by phone from time to time and what they call FaceTime, and see her. And my mom is 95 and is clear. She's physically unable to get out of bed, but she's mentally very clear. Except just about every time I talk to her, she thinks something has been stolen. And what it typically turns out to be is she cannot find it. And, an accusation of something has been stolen from an individual like my mom may often turn out to be inaccurate. But if you took it on face value, it would be some crime has been convicted. She wanted a radio for Christmas. She said, make it a big radio. I think unconsciously she wanted to be able to find the radio, but she said, if you make it too small, they can put it under their coat and leave with it, kind of conversation. So many times you have to take accusations, if you will, with a grain of salt from a resident or patient of a facility.
And one of the points that Greg is driving home there is that you got to develop a reasonable suspicion again. Taking things at face value may not necessarily rise to that level of reasonable suspicion, but if you or maybe someone else you're working with conducts a bit of independent investigation and finds that, well, Greg's mom's radio was in fact misplaced, it's not anywhere in her room, someone may or must have taken it away and we can't find out where it is. In that event, maybe there is a reporting obligation, but not just on the face value of the report itself. Yeah. Okay, another example. And we recognize that this may not be something that actually comes to the attention of you in your role as a medical director, but again, just to illustrate the types of things that might constitute abuse, neglect, exploitation, etc. under Alabama law. Say a family depletes an individual's financial resources. They're paying themselves because they've been taking care of mom and dad for years and years, and they want their just reward for that. This is kind of a delicate situation in and of itself. I'll reach back to my experience at the Alabama Medicaid agency. Alabama Medicaid for years has had a requirement that if a family member were to be paid to take care of an individual before they go into the nursing home, it had to be done pursuant to a written agreement, had to be done at fair market value, et cetera. There were several requirements. Otherwise, a transfer penalty might be imposed against the individual, and they might not become nursing home Medicaid eligible for a period of time. I've had different experience with that when actually going to hearings on that type of issue. I think there's been more latitude from administrative law judges to allow informal agreements where it's plainly obvious that a family member was taking care of their relative and was really just reimbursing their reasonable cost of doing that. But let's say that the family member is not actually or has not actually provided any services or care to their elder relatives, let's say their mom or their dad, and really what they were doing is just taking money for themselves because they were in a pinch and needed it. That for certain could be exploitation. It could be, I guess, depending on who is taking those funds, again, very much could be exploitation, misappropriating the individual's resources for other than the person's best interest.
As Chris says, this is something that would be hard for you to detect typically. An example that I'm aware of that happened was an elder person went into a nursing home who had some resources, enough that Medicaid was not paying for their care. They were their own personal resources paying for the care. And the individual, their child, when they began to come to the nursing home, drove a 20-year-old vehicle. And at some point thereafter, they came with a brand spanking new vehicle, a very expensive vehicle, and said, someone said, where did you get the money to buy the vehicle? Well, I used mom's money. Literally said that's what they did to get myself a new car. I've been taking care of her for years. She owes me something. So, it can be a little bit open and notorious, but not very often.
Run through a couple more examples here. I don't mean to pick on our good friends that are running nursing homes. Obviously, the Nursing Home Association is a sponsor in the state. So again, this is a heavily exaggerated example, but something to try and make a point about one of these definitions under state law. Let's say a nursing home is withholding a patient's personal needs allowance. They're $30 that they get to keep outside of other income that's required to be paid to the nursing home. And they do that, they withhold that personal needs allowance to recover fees owed by the patient for beautician services or some other non-covered services. And they do that without the patient's consent. Again, on the face, it's very hard to tell whether or not this is actually a abuse, neglect, exploitation, or a crime in any stretch. For instance, I imagine the resident signed a resident agreement that included some financial responsibility for non-covered items. Now, whether or not that can be taken out of the personal needs allowance, we won't get into that. But again, there's probably something in the resident agreement that specifies the resident's responsibility for non-covered items. The patient or resident may have given their consent to use some of those funds to cover the beautician services or other services. Point being, it's not always very clear cut. It's certainly not on the face of things that you might be able to observe, but I guess there is at least a potential instance of misappropriation of nursing home resident property in this case that could be, if there is a reasonable suspicion, reported under the Adult Protective Services Act in Alabama. I told you I don't have any jokes, but I'll try and tie in a couple of pop culture references, and this may date me, and I'm not sure if it's a good thing or a bad thing, because even this reference is probably 20 years old now. But let's say, our good orderly here has a resident come up to him and ask them for a warm glass of milk that can help her sleep, and the orderly responds that this resident can trouble him for a warm glass of shut the hell up, and says, "You will go to sleep, or I will put you to sleep." Now, this was funny in the context of the movie, but obviously if you hear that in an actual real life scenario, that's a pretty troubling type of statement to be made by one of the facility employees, whoever that might be. And, you know, was conducting some interviews the other day and heard about some pretty foul language like that being used about residents and in relation to residents of a facility. What kind of conduct might this be? In some circumstances, I mean, it would naturally seem to be emotional abuse. You know, willful and reckless infliction of mental anguish or emotional distress on that resident. But could it also be, you know, true abuse, notwithstanding the emotional abuse? If this orderly is withholding some needed services for the health and welfare of this resident, I think that's probably more of a stretch, but certainly seems to be emotional abuse in this circumstance. And one last example, this really, really dates probably everyone, but our good friend, Nurse Ratchet, in a psychiatric hospital, it's a nurse manager, and she is delivering excessive amounts of antipsychotics and also emotionally and otherwise controlling residents or patients in her psychiatric facility, some of whom are elderly individuals. This could be any of a number of things under the Act. It might be a physical abuse. It could also constitute, in fact, emotional abuse. You wouldn't think of it naturally this way, but again, Greg and I were talking about how legal definitions and our common sense of certain terms are not always the same. The definition of emotional abuse under the Adult Protective Services Act in Alabama would also include administration of medications to try to control the behavior of an individual and to do that inappropriately. So in this case, Nurse Ratchet may or may not have conducted some abuse and or emotional abuse against a resident or patient of that psychiatric facility. Little bit different question about whether or not that psychiatric facility, psychiatric hospital, or let's say a psychiatric unit in a general acute care hospital, probably not going to be considered a long-term care facility for purposes of that Elder Justice Act under federal law. So in this case, you may have a state law reporting requirement, but not have that reporting requirement to the Secretary of HHS or to local law enforcement under the Elder Justice Act. Again, apologies for some contrived and really just over-the-top examples, but we're trying to make a point about how this type of conduct might fit into reporting requirements under the Act there. Oh, wrong way. And somebody I know asked a question earlier as Greg and I were transitioning over, how do we report this stuff when we observe it in a facility? And you know, how do we follow up at all and make sure that something gets done? We've provided here a number of different avenues to report abuse, neglect, exploitation under the Adult Protective Services Act. Again, you can report to the central DHR office here in Montgomery. I think the Act also speaks to reporting to local DHR, so your local Department of Human Resources would also be a resource to report abuse, neglect, exploitation to under the Adult Protective Services Act. We've also got reporting lines for the Department of Public Health for nursing home and assisted living facility complaints. I think those are in order there, the first one being nursing home, the second one being ALFs. The Elder Care Locator is one of the reporting hotlines for the Elder Justice Act on the federal side of things. And obviously get in touch with your local law enforcement too to report these things. Again, under state and federal law, each having the option or the requirement to report to local law enforcement as well. With that, does anyone have any other questions about what we've covered this morning?
We actually do have a few questions. So Dr. Harrison says, should this organization, talking about petition or file a class action to try to require DHR to follow their regulation law to protect our patients?
The question is, could a class action be filed to force DHR
Yes.
to do something. I guess potentially, class actions, first of all, generally are for everybody but the government, you know? So trying to, oftentimes the government has, you will do this, we don't necessarily have to do it, kind of unfortunately. But I guess it is a possibility. The government is or has been successfully sued for failure to do what their law says they're supposed to do. I am not aware of any situations where this particular law has been used for such a lawsuit.
But I guess the example here in Alabama would probably be the prison system has been the subject of federal district court litigation for years and years about Alabama's correction system not living up to standards for, I guess, inmate safety and rights. Even if, you know, they're convicted felons, they still have rights under Alabama law, under federal law, and the Constitution. And, you know, if let's say DHR in this case is not protecting the rights of these elder residents, then potentially there could be a lawsuit brought against them. I think another issue that you'd run into is finding an appropriate plaintiff or plaintiffs. One of the things that, you know, as I push my glasses up on my nose, we attorneys worry about in lawsuits is standing, having a proper person bring the lawsuit that has a vested interest in the outcome of the case. And that's not to belittle your role as medical directors and your interest in having your residents be protected by the Department of Human Resources and others, but typically you need somebody who has had a concrete injury, and in that case, that would be the residents that have potentially been subject to abuse, neglect, and exploitation that would have to bring the lawsuit or have it brought on their behalf.
There's another organization which we don't have mentioned here. We could get that from Megan to share. It's called ADAP. It is located at the University of Alabama Law School. Each state has one of these agents. It's manned by attorneys, and where someone believes that someone who is disabled, and many elderly people would qualify as a disabled individual, they can investigate situations and potentially bring a lawsuit against the provider for failure to do what they should do. Alabama Disabilities
Advocacy Program.
Yeah, ADAP.
We've also got the State Long-Term Care Ombudsman.
Yeah.
There and Department of Senior Services here in Alabama that all do work to protect elder citizens in the state.
Great. Okay, we have one more question. How is anonymous reporting handled?
How is it?
How is anonymous reporting handled?
Oh, well, you know, part of this, I don't know that I would necessarily recommend, at least the kind of situations we're discussing, doing something anonymously. You know, in case something comes up later on, if you've reported something anonymously, it may be difficult to show you've reported it all when there's an obligation to report. That is to say, you know, that there's nothing saying you can't, but I would suspect there would be some suspicion on the part of law enforcement and or DHR if they get an anonymous report as opposed to someone who's willing to state, my name is Greg Everett and I'm a nurse at XYZ assisted living facility or whatever.
I would say at the very least, you know, I think we understand the concern about reporting anonymously, especially if you might suffer some negative consequences from, you know, whatever facility you're reporting on, and you don't have anti-retaliation protections. You might want to make a report to satisfy your obligations and protect your patients under the law, but not have those adverse consequences from the facility that, you know, the immunity protections under Alabama law don't really cover immunity from adverse action by another private individual or company. So we understand the, you know, perhaps concern about anonymous reporting. I would say at the very least, you want to document the time you called, who you spoke with, and have those notes ready as a present sense impression of what you were reporting, who you reported it to, et cetera, so that, you know, even though that report is anonymous on the other side of the call, you've got your notes to prove that that's who you spoke to and to corroborate that that report actually happened.
Yeah, anytime any of these oral reports mentioned, I would make good notes to yourself, because, you know, things may come up a year or 2 years later and, you know, you don't remember the date or who you spoke to or whatever. So something to help you recollect, you know, when questions arise.
As Greg said, the justice system moves slowly,
Yes.
frequently, so it's not out of the realm of possibility to have to recall back a year or two before things happen.
Yes. Unfortunately.
All right. I don't have any more questions right now. So we will move on. Thank you so much for being here today and speaking to the group. I know it's really appreciated, and we will have your information to send out to everyone in the packet. So they'll have that if they want to reach out to ask any additional questions.
Thank you, Megan, and thank you for the invitation to speak this morning.
Thanks everyone for your time and attention this morning. And Megan, I'll turn it back over to you.